Hi there, I'm attorney Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about how the Corporate Transparency Act may impact your estate plan. So starting on January 1st of 2024, under a new law called the Corporate Transparency Act, owners of certain business entities must file a report with the federal government, including details regarding ownership of their entity. The CTA was enacted to help combat money laundering, financing of terrorism, tax fraud, and other illegal acts. If you have an entity, a corporation, or a limited liability company, family partnership, etc., as part of your existing estate plan, this is important information that you'll need to know to ensure that you comply with the new law. So just what is the Corporate Transparency Act? The CTA is a law that requires business entities to identify as reporting companies to disclose certain information about the company and its owners to the U.S. Department of Treasury Financial Crimes Enforcement Network. Now, under the CTA, a reporting company is defined as a corporation, a limited liability company, or other similar entity created by filing a document with the Secretary of State or a similar office under the laws of a state or Indian tribe, or formed under the laws of a foreign country and registered to do business in the United States. Now, the following information about the reporting company must be included in the report. So you have the company's legal name and any trade names or doing business names. You have the street address of the principal place of business, the jurisdiction where the business was formed, and then the tax ID number. Now, additionally, the reporting company must provide the following information to FinCEN about its beneficial owners, defined as persons who hold significant equity, 25% or more ownership interest, in the reporting company, or who exercise substantial control over the reporting company. So you need the full legal name, date of birth, the current address, unique identification number from an acceptable identification document. For reporting companies created on or after January 1st of 2024, the same information must be provided about the company's applicant, who is the person that files the creation documents for the reporting entity. So you may be wondering whether the CTA impacts you. Many business regulations apply only to large businesses, but the CTA specifically targets smaller entities. Now, if you own a small business, you may be subject to this act unless your business falls under one of the stated exemptions, which primarily applies to industries that are already heavily regulated and have their own reporting requirements. Your business may also be exempt from the reporting requirements if it employs more than 20 full-time employees, filed a return showing more than $5 million in gross receipts or sales, and has a physical office located within the United States. Now, complying with the requirements of the CTA is one of the utmost importance if you own a business entity and have one as part of your estate plan. We routinely create entities that might qualify as reporting companies as part of our clients' estate plans. These include LLCs and family limited partnerships. Now, limited liability companies, which we call an LLC, is a business structure that can own many types of accounts and property. These entities can be used to provide asset protection and probate avoidance. So let's talk about asset protection. Because an LLC is a separate legal entity from its members, the LLC's creditors can typically recover only business debts from the LLC's money and property, not the members' personal accounts or property. Also, if the proper formalities are in place, the members' personal creditors may not be able to reach the LLC's accounts and property to satisfy the members' personal debts. Now, a family limited partnership is an entity owned by two or more family members, created to hold the accounts, properties, or businesses that were contributed by one or more of the family members. An FLP has at least one general partner who is responsible for the management of the partnership, has unlimited liability, and is compensated by the partner for their work according to the partnership agreement. An FLP also has one or more limited partners who are permitted to vote on the partnership agreement, but are not authorized to manage the partnership. The limited partners receive the income and profits of the partnership, but have no personal liability for the partnership's debts or obligations. Now, for asset protection, the estate planning strategy is useful because FLP can help protect accounts, properties, and businesses held by the entity from your and your family's creditors, because those items are not owned by you and your family as individuals, but instead are owned by the entity. If a creditor obtains a judgment against you or your family for a claim not related to the FLP, it is more difficult for the creditor to access anything that the FLP owns to satisfy that claim. Now, from a tax planning perspective, because of its lack of control and restrictions on selling a partnership interest, the value of a limited partnership interest that you give to a family member can be discounted, allowing you to maximize your annual gift tax exclusion and lifetime estate and gift tax exemptions. In order to comply with the CTA Act, you should gather the required information for all reporting companies you own and all other beneficial owners. For entities created before January 1st, 2024, submit the initial reports for each reporting company by January 1st of 2025. The current requirement for reporting companies that are created after January 1st of 2024 is that the initial report is due within 30 days of the entity's creation. Now, please note, however, that a new rule has recently been proposed that would temporarily extend this deadline from 30 to 90 days for business entities formed during 2024. If implemented, this rule would allow additional time to understand and comply with the new requirements. Now, having a business entity as part of your estate plan can be an excellent tool depending on your unique situation. If you currently have one of these entities or are considering forming one, please reach out to us to discuss the next steps to ensure that you fully comply with the requirements of the CTA. I want to thank you for watching. I'm attorney Kelly Longtin, and please like and subscribe our page below to learn more about estate planning and the benefits it can offer you and your family.